they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My notes, if it pleases the court, my name is Andrea Mohi. I am acting in person. We filed an application for a certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 14th of October, 2024. Unfortunately, some of the records we were seeking have been overtaken by events. My Lord, and today, as the heart of our application has not been placed before you, and we are just concerned that our application will once again, events will once again overtake our application. My Lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Grima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Boy applying for an adjournment? Because he's saying, and perhaps it's wrong, that even the recusal application comes after the termination of the question when panel. If that be so, and they may leave, they normally leave court, they left Senate, may leave court. We let them say whether they are applying for adjournment.
Is that the mark they normally leave court where the left Senate, my palatable in this court, my Lord? I need that.
No, because it's an adjournment.
No, is that the mark palatable before my Lord and my Lady? But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a vague application for adjournment. Because Mr. Ward is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I need to withdraw. I want him to withdraw first, my Lord, because I'm entitled to dignity.
I have no problem with withdrawing. Okay, my friend, no, I have no problem, my Lord. I will withdraw the remark, but there is practice.
Thank you. Let me now address the question as addressed. My Lord, Professor Genda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Gideon Mungai, and learned colleague, Mr. Njegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Kidu Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and this, or should have, they would have found out. The letter which was written this morning, which we have, it was received on the 20th of October, has actually one pertinent question disposed whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That, as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard?
Yes.
My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the applications which have been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond. The application for conservatory orders. And my lord, you also hear our application to set aside the conservatory orders. My lord, that will make juridical sense and promote public interest. Thank you.
My lord, if I may just add,
this court has the control of the proceedings. And this is a very weighty matter. It concerns the deputy president of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
Halipo ama liliweza kuletwa pamoja visivyo ama kinyume cha sheria, ikisema kazi hiyo ni ya jaji mkuu na kwamba jopo hilo liletwa kwa pamoja na naibu wa jaji mkuu. Hivyo basi, mtazamaji wangu, ni kusema hata kesi ya naibu rais Dp Gachagua aliyebanduliwa kupitia bunge kuu na lile la seneti bado haijaanza kusikizwa. Kikuu zaidi ambazo kimeweza kudhihirika hapo